Printing and More is located in Smithfield, but serves all of Hampton Roads. They specialize in vinyl design shirts, apparel, window stickers, cups, and other specialty gifts. They also have rhinestone and embroidery designed apparel, and they offer Pandora-style beads and hardware to create a one-of-a-kind piece of jewelry. RM Designs T-shirt Printing and More caters to businesses, sports teams, churches, groups, and family reunions. They also offer a great fundraising package should you be in need of money for a special project. And they also do home parties if you and your friends would like to get together and make your own creations. RM Designs T-shirt Printing and More can be reached at 757-255-9140. That's 757-255-9140. Email them at rmdesigns11@aol.com or find them on Facebook at RM Twisted Designs. You can also place orders directly off their store at storenvy.com/RM Twisted Designs.
Okay, so we're back. I'm George Yates, and this is Justice for All. I'm talking here about when you can represent yourself, how you might represent yourself in any kind of a case, whether it's a criminal case, a traffic case, maybe even a personal injury case, or a civil case. And once again, most of the time, all these skills that you learn, perhaps in how to learn to represent yourself, can be used whether or not you represent yourself or whether you're actually working with your own attorney. My experience as a defense lawyer, criminal defense lawyer, and as a personal injury lawyer, I've determined that the people that are in the best position to do well and with a lawyer are also the ones that are really trying to represent themselves with their attorney. And that means that, now let's say it's a traffic case. Well, the person that's charged with a traffic case, can they go defend themselves in traffic court? Now, that's probably the one that's the most likely for somebody to try to do without an attorney, because they're not really looking at the most serious offense in the world. They're not going to be looking at some jail time if it's just a speeding ticket. How do you defend yourself in a speeding ticket? Well, first thing you got to do is be polite to the officer when he stops you, and be very cooperative, because if he likes you or she likes you, well, then that means that maybe they're going to be inclined to present that to the court, and the judge is going to like you from the get-go because you were cooperative with the police officer. Second thing you need to do is you got to go down to the Division of Motor Vehicles before you ever go to court and get a copy of your traffic record. You don't necessarily have to show it to the court. You might have a bad record, but you at least need to know what it is. A lot of times police officers don't run your traffic record. If they might run it, and if it's good, they'll let the court know that. But the judge does not have a copy of your traffic record there available to him or her on the bench. So you go down to the DMV, you pull out a copy of your record. You want to show that to the judge. If it's a speeding ticket, you need to go get a calibration on your vehicle because that could show that maybe your speedometer was off. You need to come to court armed with those two documents. Now, you also need to, before you even go to court, and you need to do what does a lawyer do if he's representing you in a traffic case? Gets there early, goes and finds the officer, and walks up to the officer. Almost every good traffic lawyer goes and talks to the police officer first. He'll go in, talk to the cop, walk outside, and discuss the case with the police officer. They'll talk to the lawyer. Why won't they talk to you? So go and talk to the officer and say, gee, did you go check my record? I just want to let you know, here's my record. I ran it. I don't have any points. I've only got, I've got 5+ points. And here's my calibration that I've got. And the officer might say, yeah, you were real cooperative. You might well work this case out with the police officer and do the exact, just as well as a lawyer that you might pay, what, $250 to $500 or even more to defend you in a simple speeding ticket or reckless driving ticket. You might also, when you go check your DMV record, you're going to find out whether or not have you gone to traffic school before. You know that you can only go to traffic school every 2 years to get the 5+ points. Anybody that goes to traffic school gets 5+ points. Well, the thing you need to remember is that you can't get any more than 5+ points. So if you already have 5+, don't go to traffic school before court, because you're not going to increase your plus total. And if the judge sends you to traffic school, it's going to be too late. You've already done it. So wait, because a lot of times a judge might order you to go to traffic school, and then you can get it as a condition of your sentence. So don't just go run off and do traffic school too soon. I'm not saying never do it, but there are times when you need to decide based upon your criminal or your traffic record whether or not you should go now or whether you should go later. always be prepared to go to traffic school to get out of the traffic ticket. Now, once you've spoken to the police officer, and officers generally do not make deals. It's not like they're going to agree to give you a deferred finding or a traffic school, or agree to reduce the charge to defective equipment, or agree that some other disposition should happen in your case. But you can at least ask the officer about it. Tell the officer, like a lawyer would, that this is what you're going to ask for. Now, and if you tell the officer that, the officer might say something to you like, well, I won't oppose that. Like, if you want to ask for traffic school, I won't oppose that. You say, okay. So then you go up there and you say, well, Your Honor, here's all my stuff, and would it be possible for me to go to traffic school and not get convicted of this ticket? Well, you've just done the exact same thing that a lawyer would have done for you. Now, once again, if you've decided to hire a lawyer for this case, which is even the better course, and if you have the money, you should hire a lawyer for the case. But you've still way ahead of the game, aren't you? You've gone and gotten the calibration, which the lawyer's going to tell you to do. You've gone and gotten your DMV record, which the lawyer's going to tell you to do. And you're there in court, and you know what the lawyer is about to do for you. So you're a good client. And so you're prepared, the lawyer's prepared. So either way, if you prepare yourself to defend yourself, you're going to do better with the lawyer probably, but that doesn't mean that you can't try to go in and do certain traffic court cases by yourself if you have a good record, and so on and so forth. So traffic is one of those cases, types of crimes that, yes, you can go in and perhaps defend yourself. And always remember that if you don't get a good result, you can always appeal the case from the traffic court and request an attorney maybe the next time around in circuit court, and maybe do better if you didn't do as well yourself. So that's the thing to remember. And, of course, appeal, certainly if you've been given a jail sentence, be prepared to note your appeal. Call your bondsman before you go. No kidding. But, it doesn't hurt. Let people know, gee, I'm going to court without a lawyer. I might get jail time. Be prepared to help come post bond for me. So at least, let other people know. It's kind of like when you go hiking in the woods, let people know where you're going just in case you don't come back. So those are some skills that are helpful to you if you want to represent yourself in a traffic case. Let's say it's something more serious, like it's something where it's a misdemeanor, like we talked earlier about a neighbor case. Those are ones that are very good for not having an attorney, because sometimes what ends up happening when you've got a neighbor case is the neighbor doesn't have an attorney, so the judge ends up asking all the questions of the neighbor. Sometimes if you don't have an attorney, well, maybe the judge will kind of give you the same benefit of the doubt and will start cross-examining the neighbor case for you. Maybe and we'll certainly be asking the questions that are important to the judge, which maybe your own lawyer might not have recognized. And by having an attorney, especially an inexperienced attorney that might not know their way around a courtroom. I mean, I've seen people that have lawyers come into court and they've got a lawyer up there. I go, oh my God, why in the world did that lawyer do it in that manner? That client might have been better off without an attorney based upon what that lawyer just decided to do. There are always situations, though, where having an attorney is, of course, absolutely required. And that's where the defendant doesn't ever want to testify. Let's face it, you don't have the duty to testify in a case where you're the criminal defendant. In fact, you've got a constitutional right not to testify. And as I've said all throughout this little presentation here, my initial comment on anybody that asks, do I need an attorney for that? I always say, yes, you need an attorney. But this little presentation is for people that want to know why. Why do I need an attorney for this? Here's another perfect example. One is perhaps the whole idea of DUIs, which are very commonly prosecuted now in all these cities. There is a standard first offense DUI disposition for people that, let's say, are below under a .15. There is, let's say, a 1.1 or a 1.3. Ordinarily, you do not go to jail for a first offense DUI. Ordinarily, you're given a restricted driver's license to go to and from work. Ordinarily, you have to go into some kind of a program, the ASAP program or this and that. You're given a suspended sentence. You got one of these ignition interlock devices, and you walk out the back of the courtroom. You don't go to jail. You get a restricted license, and you pay some fines and costs, and you go put up with your bad driving record, the DUI, and everything else. And so someone says, well, I'm going to go hire an attorney on this DUI. And then they pay a lot of money to the lawyer, and the lawyer comes in and says, I can't do anything for you. They're going to convict you. And what do you get? Well, a lot of people will get the exact same disposition from the court as they would have come in if they represented themselves. And so their first thought is, well, why did I pay this lawyer all this money if he wasn't able to get me out of the DUI? I got the same result as I would have gotten if I didn't have a lawyer, and I've spent all that extra money. And that is the question, isn't it? When do I need to go hire an attorney, let's say for a DUI case? Well, we're going to take a short break here. When I come back, I'm going to tell you why or when it is important for you to have an attorney represent you in a DUI case. And there are many reasons why, and we'll get into them in the next few minutes. So stay with us.
Are you prepared to defend yourself and your family against any threat? Veteran-owned and operated One Shot Trading Post is ready to make sure that you are. Continuing training and classes on defense, survival, and weapons. Full gunsmithing services, special orders and financing available with military discounts. $15 transfers, and One Shot Trading Post is always looking to buy, sell, or trade. Located at 4366 Holland Road at South Plaza Trail, make sure that you're ready for anything at One Shot Trading Post, 463-5893, OneShotTradingPost.com.
RM Designs T-shirt printing and more is located in Smithfield, but serves all of Hampton Roads. They specialize in vinyl design shirts, apparel, window stickers, cups, and other specialty gifts. They also have rhinestone and embroidery designed apparel, and they offer Pandora-style beads and hardware to create a one-of-a-kind piece of jewelry. RM Designs T-shirt printing and more caters to businesses, sports teams, churches, groups, and family reunions. They also offer a great fundraising package should you be in need of money for a special project. And they also do home parties if you and your friends would like to get together and make your own creations. RM Designs T-shirt printing and more can be reached at 757-255-9140. That's 757-255-9140. Email them at rmdesigns11@aol.com or find them on Facebook at RM Twisted Designs. You can also place orders directly off their store at storeenvy.com/RM Twisted Designs.
Hi, this is Greg Picaveras. Join me for Sports Scene each Wednesday from noon to 1 right here on News Talk 1650 WHKT. You can also hear the show on TuneIn as well. We will talk to local, regional, and nationally acclaimed sports guests, and we'll interact with our audience as well at Greg Pick on Twitter. Sports Scene, Wednesdays from noon to 1 right here on 1650 AM.
So we're back, Justice for All. I'm George Yates, and we got another 30 minutes here on this beautiful Saturday afternoon here in Portsmouth, Virginia, and I hope you're having a great afternoon. And we're talking about when you can represent yourself and how you go about representing yourself in certain kinds of cases. One of the main things people will call me about sometimes is a child support case. They want to know, they want to get a lawyer to represent them in a child support case. I'll almost always tell them, no, you need to go represent yourself in a child support case. Why? Well, because child support is such a numbers game anymore. It's all based upon how much money you make, how much money the other party makes, the other parent makes, child care expenses. It's such a numbers game. And you can have the best lawyer around. It's not going to really change what those numbers are. And the second thing is, even if you could change the numbers a little bit, it's not going to justify the cost of the lawyer. Let's say you're able to go in and get a child support reduction of, $100, which is a lot. Well, $100 over the course of a year is $1,200. Well, you're going to pay your lawyer probably that much just to go to court. So you're paying your lawyer the $1,200 to go to court, and even if the lawyer wins you that $100 reduction, you still take a whole year before you even get your lawyer's fees back. And that's assuming that you're going to win. So very often, I'm not trying to tell you that you never need to have an attorney in a child support case, but the fact is, any lawyer that's winning you a $100 reduction in child support, you could probably win that yourself. You can go online, you can pull up the child support guidelines, you can look at those numbers, you can crunch them yourself, you can go get all your wages, you can get all of your sources of income, the other parent sources of income, the child care stuff, the whole thing, and do it yourself. And save yourself an attorney's fees and still do a very good job. And, of course, in something like child support, you're not looking at a potential jail sentence, so the risk is not that high. And so those are kinds of cases that I think that you can definitely lend themselves to representing yourself. Let's say it's a juvenile domestic relations court case, like an assault and battery case. Let's say pushing and shoving contest or something, cops came. That's going to be a tough one to defend yourself on, although because there's so much emotion involved, and the possibility for jail time is there. Possibility of a conviction is definitely there. It's rare that I would recommend anybody that is charged with an assault and battery case to represent themselves. Now, there are some rare exceptions. Let's say there's the spouse or whoever it is, the other person has already told you from the beginning that they want to drop the charge, that they have absolutely no intention of going forward on it, that they're going to tell the Commonwealth attorney that when they get there, that the two of you have gone to counseling or whatever it is, and there's sometimes you can go ahead and try to do it without an attorney. I don't recommend it, but it is possible sometimes to do that. Ordinarily, as you may or may not know, but in assault and battery case, or domestic assault and battery cases, in the vast majority of cases, there's really only two results. Either the charges just get dropped the very first day because the party that was the victim, alleged victim of it, wants to drop the charge, or there's what they call a deferred finding. We've been talking about deferred findings today in other kinds of cases, where the whole idea of what a deferred finding is the person comes in and says, yes, I did the offense, but I'm going to be on my good behavior for a period of time, and then after a period of time it gets dismissed. That's what happens in the vast majority of assault and battery cases on a spouse or on a family member. So the case gets continued for a couple of years. You're going to anger management or alcohol whatever the reason behind the offense in the first place, marital counseling, this and that. And after a period of time, if you're in your good behavior, the charge gets dismissed. These things can sometimes be negotiated and agreed on by someone operating without an attorney. But I think it would be a mistake to do it without an attorney. In this case, I'll give you an example. Let's say that the other victim wants to drop the charge and the Commonwealth comes in and says, well, we'll offer you a deferred finding. And you might say, well, I'll take that. And so what happens? Well, the case gets deferred for a period of 2 years. It gets dismissed, maybe, assuming that you do all the things you're supposed to do. Sometimes people don't. They end up getting found guilty of the charge because you've now stipulated there's sufficient evidence. And you're under the gun. It might well be that the spouse calls the cops in 6 months, and now you're already on a deferred finding for this previous thing where you really don't think you did anything wrong, but you've just gone ahead and agreed because you went in there without an attorney. Well, if you had an attorney, the attorney might have pushed to actually get the charge dismissed altogether as opposed to the deferred finding. I mean, deferred findings are great, but only if the party is absolutely guilty of the charge. If there's something where there's a possibility of the victim wanting to drop the charge and you don't really think it rises to the level of an assault and battery charge, I never agree to these deferred findings. They're always offered, and I always try to refuse them unless the evidence is just overwhelming as if there actually was an assault. So be very careful of those situations where you're in a domestic assault and battery situation, a family member assault and battery situation, and the other person says, well, I want to drop the charge. And so you go, oh, well, then I'm not going to need a lawyer for that. Well, the fact is, the Commonwealth might not let them drop the charge. And if you had a lawyer, that lawyer might have been more persuasive with the Commonwealth than you might be by yourself. Once again, anything you say can be used against you in a court of law. You have a difficult time going and talking to the prosecutor about the case because now you're becoming a potential witness against yourself. And you run, and you don't really know what the parameters are of your case, and you're emotional about it, and so you're just not in a good position to defend yourself. So every time I run into one of these situations where I say, well, gee, maybe you're able to defend yourself in a case, I can give you at least 5 more examples of where it has all kinds of potential danger. So how about the more serious ones, like the felony cases? We've seen this a lot over the years, where especially some of your more hardcore criminals, where they're charged with serious cases, felonies, murders, and they'll say they fire their lawyers and they say they want to come in and defend themselves. And judges sometimes will say, well, you got the right. You always have the right to represent yourself. It's called pro se. And we see it where sometimes the defendant, and of course the defendant's probably not playing with a full deck when they do that. The judge has to really examine the whole situation, sometimes refuses to let them represent themselves, and you run into these constitutional arguments as to whether or not you've got the right to fire your attorneys and represent yourself. But it happens. Never recommend somebody representing themselves in a felony case, but it does happen, just as many people try to come and represent themselves in certain misdemeanor cases. And it's almost always full of problems, creating issues for them. Once again, though, if you are in a position to try to defend yourself, let's say you have decided to defend yourself in a case, though. What are you going to do? You have to, first of all, find out all the names of the witnesses in your case, get their names, addresses, phone numbers. If you don't think that you're going to get in trouble for obstructing justice or making a statement against yourself, fine. Call your witnesses on the phone, discuss with them what they might say, make sure that they're available for court. You can go down to court and request a subpoena yourself to subpoena witnesses for your case, and many people do. Is there a 9/11 transcript of it? Was there a 9/11 call? You can call down to the city and ask for the 9/11 transcript and get a copy of that yourself. In fact, I've had many clients in the past that have done that for me. They'll come in to see me, and they've got the 9/11 transcript and the 911 transcript, and they've got and the ones, once again, the clients that are in the best position to defend themselves are going to be the best clients for the lawyer, because they've got the names of the witnesses, they've got their addresses, they've got their phone numbers, they've got summaries of what the witnesses are going to say. They've already done a narrative. They've written out in a long email all the facts of the case. They've written out a nice biography about themselves. They give you the whole fact situation. They've kept a copy of the police report. They've got a copy of the 911 transcript. These are the people that might be in a position to defend themselves, but are going to do even better with an attorney. I talked about a DUI. When should you defend yourself in a DUI, and when should you not? And the question came down to, well, how am I going to do any better? Isn't it true that I'm probably going to get just all suspended time on a first offense DUI if it's below a certain amount? Well, the people don't know all the laws. If you've blown a .15, you've got mandatory jail time. If you got a .20, you've got even more mandatory jail time to serve in a DUI case. And here is the real secret, which is going on right now under our feet, and that is that judges are now beginning for the first time to give jail time and substantial jail time to people for first offense DUIs. So now it's really changed the whole way that prosecutors are handling DUI cases here in this area. Where it used to be that it was just an automatic that nobody goes to jail for a first offense, that is changing. Sure, it might be charged as a first offense DUI, but it might be something a little more egregious. It might have been there was an accident involved. It might have been the person was very uncooperative with the police officer. It might well be that there's a situation where this person has a little bit of a record, like maybe there's a drunken public in their past, even though it's a first offense DUI. There's a couple of other alcohol incidents that the judge sees when he's deciding what the sentence is. And so or maybe it's an accident case, and the behavior of the first offense DUI person before that accident was particularly egregious. Maybe you get to court, and these prosecutors have come in and they've gotten really, really tough now. And even on first offense DUIs, if there's an accident case or there's a prior record for some other kind of alcohol incident or any other kind of record, they're not necessarily demanding jail time, but they're presenting the case in such a way that if a judge just might well give jail time in a first offense DUI. And here's the other reason why you have to hire a lawyer in a DUI case. Even if you think that the disposition of your case is going to be the same, you don't know whether or not you could have gotten out of that DUI. Now, the fact is the vast majority of people are being convicted of DUI no matter what. But how do you know if you're one of those? How do you know that you might have had a defense in that case unless you had somebody look at it? So, unfortunately for many people, what they end up having to do is they've got to hire the lawyer to go take a look at the case, file for discovery, get all the paperwork, review the matter, and then finally pronounce that, well, there isn't a defense. And they go, gee, I'm not going to do any better than I would have done than if I'd represented myself. Well, no, but at least you know that you don't have a defense in the case. And you're not going to know that unless you hire somebody that as an expert knows how to find out whether or not you have a defense in the case or not. So that's the two reasons why you have to hire a lawyer in a DUI case. A, you got to, number one, know whether or not you're going to be found guilty of it. And number two, judges are now giving jail time for first offense DUIs. How do you know you're not going to be one of those? And you come in and defend yourself. Maybe you're one of these people that gets emotional and gets uncooperative, gets a little, I mean, there's a lot of people that you come in, they come in and ask me to represent them after they've already been convicted and given a 100-day jail sentence in lower court. And I'll go, what in the world? How in the world did you get 100 days for this offense? Well, the fact is they came into court unrepresented, and because they did not represent themselves properly, because they said the wrong thing, they might have been belligerent, they might have been disrespectful to the court. And all you got to do is do that a couple of times. Be abusive to the other witness, be abusive to the police officer, be abusive to the court, not present your case properly, and show disrespect. And the next thing you know, instead of getting some kind of suspended sentence and a slap on the wrist and walk out the back of the courtroom, the handcuffs are being slapped on you, you're being sentenced to a big jail sentence, and now you're having to note your appeal, and now you're having to go hire a lawyer to fix what should have probably been done right in the first place. So remember, when deciding whether or not you want to defend yourself in a case, you got to look at your risk. You got to look at the downside. What is my risk if I defend myself? And what are the benefits of hiring counsel? And obviously, if you can afford to do it, you always do it. So that's the thing on the DUI. Now, in the last few minutes of the case, I want to talk about personal injury cases for a minute. We've talked about criminal. When do you represent yourself in a personal injury case? This happens all the time, doesn't it? You get into a fender bender. It's the other person's fault. You've been banged up a little bit. You might even have been taken in an ambulance. You've gone off to the emergency room, and you're being contacted by an insurance adjuster within a day or two of your release from the hospital. And that insurance adjuster is saying what? We're going to pay your medical bills. We're going to give you a car. We're going to fix your car while, we'll give you a car to drive while we're fixing your car. And we'd like to offer you a certain amount of money right now to settle the case. And it's enough money for you to pay the medical bill. And they'll say, well, we'll give you $2,500 right now, and we'll pay your medical bills. You want to sign this form? It's tempting, isn't it? Because $2,500 is real money, and they're going to pay the bills, and that's what they're going to agree to do. Well, should you represent yourself in that? Well, probably not. Because if they're jumping all over themselves to give you that kind of money right away, their cases, I'm sure a lawyer's going to get you more money. But what's the lawyer going to charge you? Lawyer's going to charge you a contingency fee, right? Most of the time it's 33 1/3% or 1/3. If the lawyer has to sue, he's going to charge you maybe that fee anyway. A lot of lawyers are reducing rates now. We're sometimes seeing these 25% contingency fees now because lawyers are competing with other lawyers to lower their fees so they can get these cases. Now, if you turn down an offer from the insurance company and you're going to go hire a lawyer, you have to pay that lawyer at least a quarter, or 33 1/3%, a third of what he gets for you. So, is it worth my while? Gee, they're offering me $2,500. Am I going to put $3,500 in my pocket? Am I going to make $5,000 on the case? Am I going to make 10? How much? Usually, no one would consider representing themselves in a bigger case. I mean, these are the small cases that people can represent themselves on. I mean, if you've got a broken bone or a head injury or something like that, and you're off in a hospital for days, nobody would even think about not hiring an attorney for that. Way too complicated. I'm talking about the people in these little small personal injury cases. And there are, I had a case just last week where somebody called me, wanted to know if I should represent him. It was a little fender bender. It was a nothing case. He wasn't hurt. They offered him $500 right off the bat just to settle it right there. And he wanted to know whether or not I should represent him in the case. And I told him, I said, take the $500 and go. It's not, you weren't injured. They're giving you $500 just so that you don't hire some lawyer that's going to go send you off to a chiropractor for 6 months, pump up the medical bills, and try to make money on this case. And that happens a lot, and that's what it's sometimes devalues the value of personal injury settlements across the board. But those are the kinds of cases that you should say, yeah, I can represent myself. But you have to decide whether or not you want. Let's say they've offered you that $2,500. You settle the case right now. Well, you've got the $2,500 right now, as opposed to what? You go hire the attorney. Case doesn't settle for 3-4 more months, maybe, or 6 months, or a year. So what's the value of having $2,500 now, or $3,500 or $4,000 next year? Some people say, I'll take the money now, goodbye. Most of the time, it's in your best interest in a personal injury case to have an attorney, because they're, of course, going to earn their fee, so that they certainly, especially if you tell them, gee, I was offered this. Can you make more than that for me? Well, now you've certainly set the bar, haven't you? So that you can get the work out of the attorney. And here's where representing yourself really comes in. Think about this. If you are the victim of a personal injury case and you are going to represent yourself, what would you have to do? You would have to keep track of all your medical bills, every single bill, every out-of-pocket expense, every doctor's visit, every document. You would keep track of all of this, every bit of lost wages. You would also keep a diary and a calendar of the pain and aggravation, all this sort of stuff that you went through. So the person that is in a position, you would get a narrative. You would write out a narrative of the accident. You would continue with that narrative. You would get the names and addresses of witnesses to the case. And you would be prepared to prosecute the case yourself, right, as a plaintiff's representing himself, herself. So think about it this way. If you're going to hire an attorney, that's exactly what you want to do anyway. Because I've discovered over 25 years of doing personal injury work that the clients that are really informed about their case, that keep track of all of their medical bills, all of their doctor visits, as if they were going to be the lawyer in the case, then when the time comes, they have a complete file themselves. And that's going to be, they're going to ultimately end up in getting a lot more of a settlement, much more money in the case than they would have gotten. And it's and faster, and much faster. How many times we have somebody come in and we've been representing them for several months, and we're trying to get all of their medical bills together and documents. It turns out that they've switched off and gone to see another doctor and not bothered to tell us. They've received medical bills, or they've received various documents in the case and haven't bothered to inform their attorney. They've maybe experienced some kind of a relapse, maybe even had another accident, and not bothered to tell their attorney about that until after the fact. So the whole purpose of this little, if you will, this little tutorial here on how to represent yourself is really to make you aware of the fact that the best lawyers in the world are the ones who work with their clients as a team. And so if the client is prepared to defend themselves, and that means be a witness in their own case if they have to, know where the witnesses are in their case if in fact they're friends or family or somebody that they know, that knows the whole detail of the incident, of the accident, that it's knows every single doctor's visit, knows all the medical bills, and has everything, and has a total. And now they are prepared to represent themselves. They're prepared to assist their attorney so you can get the best possible disposition in a personal injury case. And if the case has to go to trial, you have to file suit because you're unable to settle the case. Well, now you're prepared to litigate it. And always in any kind of a case, always think this. We always talk about whether or not a lawyer is going to get you a good settlement or not. Always prepare the case as if it's going to go to trial, because you're always going to get your best settlements from trial lawyers, as opposed to someone that's always, you don't prepare the case for settlement, you prepare the case for trial. So we've talked about this. If you've just joined us, I'm George Yates. This is Justice for All. And we've been talking about how do you represent yourself in any kind of a case. We've talked about traffic. We talked about juvenile and domestic relations court. We talked about representing yourself in a felony matter. We've talked about representing yourself in a DUI or in a neighbor case. And all of these cases have there's going to be subtleties and nuances to it. And as I said earlier, some people are rational and they're motivated. They can keep their cool. They're intelligent. They know how to be respectful to the court. The risk is not that high, perhaps, in the case. And they can go in and they can defend themselves and do very well, especially in certain kinds of traffic cases. I'll do this a lot of times. Someone will call in and they'll go, can you go to Southampton County? Or something like that. And I'll go, Southampton County for a reckless driving ticket? I don't think so. I mean, that's just too far. And they'll go, well, who can you recommend to get up there? And I'll say, you know what you should do? You should just go get a couple $100 cash, put it in your pocket, and walk on up and go on up there and go into the courtroom and, try to find yourself an attorney that's right up there and maybe find somebody right in the courtroom. Sometimes you can save on attorney's fees if you do that, because the lawyer's already there. He's already in the courthouse. And you look up there and you say, are you an attorney? Yes. Well, can you represent me on this traffic ticket here today? Well, yeah. I've got a couple $100. Okay, well, you would do it. Well, the lawyer's going to probably be able to work out that traffic ticket for you in 5-10 minutes. And so it might well be worth his while to say, I'll if you want to pay me now for a service, then I'll go ahead and do it. And he can go talk to the police officer and show him your DMV record and show how cooperative you are, maybe work out a really good deal for you, and you've got peace of mind that way. Instead of having to pay some lawyer from, let's say, our area to drive 2 hours each way, and they got to charge you, well, an arm and a leg to go do a simple traffic case that you could have either handled yourself in the manner in which I've told you how to do it, or by perhaps just flipping a lawyer $100 or $200 just for, maybe putting in a few minutes work and working out something for you. So this will really help you in order to defend yourself. Now, let's face it, most of the time people can't represent themselves, and they don't want to, and they shouldn't. The primary reason being is anything they say can be used against them, and anything they say to other witnesses can be considered obstruction of justice if they're talking to them. And they just don't know the ins and outs of the courthouse. And so it's a real problem if they do that. But this is a possibility of doing it, especially where somebody finds themselves in that limbo where they don't qualify for the public defender, and they don't make enough money to pay a lawyer everywhere. Every lawyer wants, $500, and sometimes they say, I don't have $500. I have to go to court. I don't have $500. Or I got this neighbor that keeps dragging me into court. And after a while, I say, fine, just go into court. And try. If you find yourself in that situation, then just learn how to defend yourself. And go in and just remember that showing respect for the court, showing respect for all the, dressing yourself properly, don't argue, present your best case, be passionate, be emotional, but keep it under control, and put your best foot forward. Be prepared. And you can sometimes represent yourself and do okay. Just be aware that most of the time you can't, but if you have to, just follow these simple rules, and you can probably be successful. And always remember that if it's in lower court, like the General District Court, You can appeal anything that judge does, and then maybe go get an attorney to represent you in the circuit court to get you a better result if, in fact, it doesn't go as well as you were hoping it would go. Thank you for joining today. This is Justice for All. I'm George Yates. Join us again next Saturday from 2 to 4. I'd like to thank Bernard Carrick, who was on the first hour. He's the author of From Jailer to Jailed. And next week, we've got another really great guest, another great author. And you have a great Saturday afternoon. Bye now.
CBS News, I'm Steve Dorsey. Right now, it's an historic face-to-face meeting between President Obama and Cuba's leader Raul Castro. It's happening at the Summit of the Americas in Panama. That's where CBS's Pam Coulter is live.
Steve, the president has indeed begun his brief, informal meeting with Cuba's Raul Castro, a history-making encounter symbolizing the end of Cuba's 5 decades of isolation by the U.S. Mr. Obama has made it clear on this trip that he's pursuing the diplomatic opening to make life better for the Cuban people.
There are still constraints on the ability of the Cuban people to express themselves, or to organize political parties, or to start a business.
Before the meeting, Castro said he didn't blame President Obama for the mistreatment of his country. Steve?
Walter Scott, the man killed by a North Charleston police officer, was laid to rest today. CBS's Steve Futterman was there.
For the most part, the tone of the service was one of remembrance and prayer, but there were also calls to action. Members of the congregation were urged to use their cell phone cameras if they ever encounter improper actions by police.
8 elderly people are dead from carbon monoxide poisoning by a car left running in a garage attached to a Queens home. A warning now.
It's a scary thought, said Dix Hills Fire Chief Robert Fling. Right now, your home could be filling up with carbon monoxide, and you would not even know it unless you have a CO detector.
Low-level exposure starts with headaches, flu-like symptoms, and it could quickly progress, depending on the concentration in the house, up to unconsciousness. And once you're unconscious, basically death follows that.
He said make sure it's in working order.
You should replace all the meters in your house every 10 years, according to your data manufacturer, and you should replace the batteries twice a year.
Now, homes for our wounded warriors.
The flag flies from each lamppost on Main Street in honor of Marcus Dandria.
Just like any other family, we just want, a place to call home.
Marine Corporal Dandria lost both legs in combat in Afghanistan in 2011. Now he and his wife Victoria have broken ground on a house being built for them.
We never expected anything like this at all.
The house will have widened doorways, roll-in shower, and other useful adaptations for a wounded warrior. The group behind it, Homes for Our Troops, has built 184 such houses in 37 states. Dick Iuliano for CBS News in Haymarket, Virginia.
At the Masters in Augusta, Tiger Woods now in the top 10.
Putt that he start just outside left. It is quick and will wiggle back down the hill to his right. Back through, down the slope, cutting to the hole, and it catches the left lip and goes down. The crowd has erupted.
Woods hasn't won the Masters in nearly 7 years, but 21-year-old Texan Jordan Spieth still has a commanding lead. This is CBS News.
They say life is about choices. So let me introduce you to one of the best choices you can make in life. Grainger Choice. The Grainger Choice product line has just about everything we need to keep this place running. From batteries to V-belts, safety to sump pumps. And with Grainger Choice, we can trust that every product is dependable and cost-effective. When it comes to making life choices, here's a great one. Grainger Choice. Get it? Got it? Good. Call clickgrainger.com/choice or stop by. Grainger. For the ones who get it done.
Hello, America. It's me, Richard, H&R Block Tax Pro. Did you know that more than 70% of Americans get refunds? If you haven't filed yet, there's no better time to come in and let the tax professionals at H&R Block get you every penny you deserve. Visit hrblock.com to schedule an appointment today. Same-day appointments are available, but they're filling up fast. Get your billions back, America.
Not everyone gets a refund. Statistics based on IRS data.
A possible Shakespeare discovery.
To be or not to be a Shakespearean play? That is the 300-year-old question about double falsehood. In 1728, a Shakespearean expert controversially claimed it was based on a play by the Bard.
Not love, but brutal violence prevailed.
University of Texas researchers have now created a psychological profile of the writer using sophisticated text-analyzing software. Psychologist James Pennebaker.
The evidence is quite strong that Shakespeare was the primary writer.
The play centers on an episode in the Spanish novel Don Quixote. Larry Miller, CBS News, London.
One athlete takes on an amazing feat. He's run the equivalent of 100 marathons in 100 days. That's almost 3,500 miles across the country. He crossed the finish line in his last marathon in New York. His grueling run has so far raised $130,000 for an Ethiopian clean water project. Steve Dorsey, CBS News.